the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please.
Good morning.
Case number 23-3126, United States of America versus Gerardo Gonzalez-Valencia, also known as Lalo, also known as Flaco, also known as Silver, also known as Silverio, also known as Eduardo, also known as Lane, appellants. Mr. Burstein for the appellants, Ms. Allen for the appellate.
Good morning. I just want to note that Judge Henderson is not able to be here today, and she intends just to listen to the recording of the oral argument, and she'll decide the case based on the record and the oral argument that she'll listen to. We're ready to proceed with the first case. Mr. Burstein.
Thank you, Your Honor. Morning, Your Honors. Devin Burstein on behalf of Mr. Gerardo Gonzalez-Valencia. Mr. Gonzalez-Valencia pleaded guilty to the sole count of the indictment, conspiracy to import cocaine. He was found to have accepted responsibility for his conduct. And in exchange, the benefit he received for his bargain is a life sentence.
Well, there was no bargain, was there? He pled to the indictment with no plea agreement.
He waived his rights to a jury trial, to confrontation, all the other panoply of rights that come along with the trial right. And the benefit.
But he did that with no bargain. There was no agreement with the government. They didn't agree to anything. He just pled to the indictment.
And as a result, he was sentenced to essentially die in prison. We believe there's no justice in that sentence and that it should be vacated for several reasons. I think the most straightforward reason is that we know on this record that Uruguay was absolutely clear at every level of its judiciary and executive that whether binding or not, its expectation was that he not receive a life sentence. We know that that was heavily discussed in the sentencing papers. All of the papers that the government put in the supplemental appendix show those documents. They were all before the district court. And what is silent in the record is whether the district court considered any of that in fashioning its sentence. That's a very important consideration because it stands in stark contrast to the majority of the types of issues district courts day in and day out base their sentences on.
But your client's counsel didn't ask the court to explicitly address that on the record. Your client's counsel was given that opportunity when the court said, anything else? Is there anything we're missing? Anything else we should discuss? And
right. And so
your client's counsel never asked.
Right. So
for that, what you're saying should have happened.
Correct, but.
Okay.
Okay, so correct, but. The ask was ahead of time. That's the point of litigating these things. And then I understand the government's argument. So when I say that, I hope I'm clear. The ask was
in the papers.
In the papers and in all of the documents that were filed. And that's the point. And then the district court imposed sentence, said life. It wasn't like before I imposed sentence, anything else. Imposed life and then said, are there any further objections? And really, it's such a form over substance thing. We know she imposed life. So what he was supposed to futilely say, oh yeah, but you forgot this. I mean, it's just.
But presumably there was an allocution before she pronounced sentence. And was there a request at that point that she specifically address this issue?
Well, no, but it's the same thing we're doing right now. It would be like, well, you didn't mention in oral argument counsel this point in your brief. It's like, right, Judge Pan, because that's why I wrote you a 35-page brief, because I don't have time to discuss everything. And if I started to repeat my whole brief, I think both yourself and Judge Randolph would say, counsel, why are you reading your brief to us? We've read it. So right, the oral argument portion of the sentencing was to address the court's questions. The court controls the oral argument portion of the sentencing, just like this court controls my questions. The whole thing that I find incredibly troubling about this whole line is this is not supposed to be a gotcha game where we're bureaucrats saying, oh, he didn't dot this I, he didn't dot this T. Our job collectively is to do justice. And here we have a real issue. USCA was clear as can be. Don't impose a life sentence. Maybe that would impact the judge. Maybe it wouldn't. But shouldn't we know the answer to that before we sentence somebody to die in prison? And I hate the term life in prison because it's such a euphemism. We don't have parole. This is not a California kind of or state court thing. Life is life. You leave in a body bag. And I just don't want to let's not put a smiley face on that. This is as serious as it gets, but for the death penalty. And we have something that is undisputed that we don't know the answer to. And there is
Our case law says that a district court doesn't have to address every argument that's in the paper.
Of course.
And your client's counsel did not ask her to address this. So like you said, this is not a gotcha game. It's also not a gotcha game on the district court.
Our counsel, respectfully, have to disagree. Do I agree that the lower counsel below should have done a better job? Yes. Could counsel for the government have also raised it because it was in their papers? Yes. But to say this wasn't raised, I don't think is fair, Your Honor. It was raised. All of these documents were before the judge.
But your argument in your brief is that she should have discussed it on the record. And nobody asked her to discuss it on the record during the sentencing hearing.
Okay. And so we're left, all I can say to that is yes, that's true. And then that begs the question. So what does this court do? Can this court look and say that as a matter of international comedy, as a matter of the strong preferences, as a matter of protecting United States citizens in the same position overseas?
As a matter of plain error, which is the standard of review.
As a matter of plain error, should the court have looked at this? Because
how can you meet the plain error standard when we have case law that says a court doesn't have to address everything in the papers on the record at the sentencing hearing?
I can easily meet the plain error standard. Bigley is a plain error case where it was reversed for failure to address on the record a non-frivolous argument. This court has a whole bigger body of law that makes the essential point because it's a common sense point. Judge, if you have a major issue for mitigation and you don't say anything about it, we, sitting as the Court of Appeals, aren't sure you considered it. If we aren't sure you considered it, we can't affirm your sentence because somebody could be doing life in prison on a mistake. We don't do that in America. That's what separates us out. And I'm not asking the court, send it back for a new trial. The sentencing transcript was 63 pages. It would take Judge Howell 10 pages. We can all go back and do this in 15 minutes, and then we can look at ourselves in the mirror and say, if he gets a life sentence despite what Uruguay said, then we know at least we've done our job. Due process has been had. Justice has been served because we know she considered the point. What is the harm? Imagine we're sitting here in
What is the harm is just not the standard that we're applying here.
But imagine a parallel universe, Your Honor, where we do know. And she says, you know what? I didn't consider it, and I'm going to give him 35 years. And instead, and that universe exists. But instead, we said, you know what? We're going to get overly focused on the standard of review, and we're going to hang our head on that. And too bad, so sad, you die in prison. What's more just? What speaks better of the American justice system to the man on the street, to the woman on the street? That we got it right because we knew there was an issue that needed to be gotten right? Or that we said, you know what, your lawyer messed up and didn't use the right phraseology and his talismanic words weren't enough. And so sorry, you die in jail, sir. That's not who we are. That's not our values. I don't think anybody as an officer of this court would appreciate that kind of ruling over one that just simply said, let's get it right.
So You make an interesting point, and we are a court of law, and the plain error standard is intended to promote justice because it says that even if you don't raise something, we will correct it if you can meet these four prongs of the test, and we'll correct it anyway, even if you
Right.
didn't preserve it. And so the whole structure and system of that standard of review is to promote justice.
Right.
Just still have to meet the four prongs. It's not a general, it would be just, it would be fair for us to do something. That's not what we're doing here. We're a court of law. We're applying a standard. The standard promotes justice. And you have not shown how you meet that standard, the plain error standard.
I disagree, Your Honor. We did show it. I quoted to you bigly. I disagree with the exact premise. This is a common law court derived from both courts of law and courts of equity. 28 USC 2106 gives this court express authority to do exactly what I'm asking. And we clearly meet the plain error standard, even in its standard form. The plain error standard, one, error. This court's law is crystal clear. The district court must address non-frivolous arguments. You're shaking your head, but that's what this court's case law says.
Our case law says that the district court isn't required to address every argument.
No, it says it's not required to tick off every 3553A factor. It doesn't say it's not required to address significant non-frivolous arguments. That would be a
The
nonsense.
fact that we're having this disagreement means it's not plain, clear, or obvious, is it?
I
It has to be plain, clear, and obvious.
I would point this court to Bigley and to Borda, and it is obvious. This is as obvious as it can be. And if it's obvious, then the district court had to do it. If the district court had to do it and didn't, that's plain error.
That I agree on.
Okay.
No.
Okay, thank you. We'll give you 2 minutes for rebuttal.
Thank you, Your Honor.
Ms. Allen.
Thank you, Your Honor. Catherine Allen on behalf of the United States. I just want to make sure that I clarify one thing here regarding the merits of the argument that counsel was making, which is just, I want to just walk through exactly what happened with respect to the extradition. He is correct that the initial request from Uruguay did request that the United States make assurances that he would not be sentenced to life in prison. And the United States responded and did not provide any assurances. And that's at supplemental appendix, that's at supplemental appendix 173 to 176. The AG's, the Uruguayan Attorney General's letter confirms this. At supplemental appendix 95, it states that the Attorney General's office, quote, understands that, quote, the failure to provide guarantees with respect to the non-imposition of the sentence of life imprisonment is justified. So I just want to be very clear that there were never any assurances by the United States in the extradition process that he would not be sentenced to life imprisonment.
Is there anything in the sentencing guidelines that deals with this type of a situation where the country that is, where the individual is being extradited from makes a request with respect to sentencing? Is there anything in the guidelines that deals with that?
Not that I'm aware of, Your Honor. And, this argument was raised for the merits argument was raised for the first time in his supplemental sentencing memorandum after the evidentiary hearing. And it was raised, separate and apart from his arguments about the guidelines and separate and apart from his argument about the 3553A factors.
And the guidelines, the guideline calculation resulted in a life sentence. Is that correct?
That's correct, Your Honor.
And so that nothing in the guideline sentence would change as a result of Uruguay's request.
Not that I'm aware of, Your Honor. And just to be clear, it was only Uruguay's initial request that requested assurances that the United States not sentence him to life imprisonment. But then after the United States responded, did not provide those assurances, the Uruguayan Attorney General's office recognized that the United States had not provided those assurances, and Uruguay then nonetheless still extradited him. So we think that it's very clear on the merits that there was no, ultimately there was no condition and there were no assurances that he wouldn't be sentenced to life in prison. And
the import of Judge Randolph's question is, if the district court were to take this into account, it would have had to downwardly depart or vary from the guidelines in order to account for Uruguay's position.
That's correct. And sorry, I was just trying to make clear that we don't believe that was Uruguay's position as a factual matter, because
Well,
it extradited him.
Uruguay's position may be, we would prefer that this person not get a life sentence, but it's not binding. The United States didn't say, okay, that's a condition of you giving, none of that happened.
Exactly. And
But understanding that Uruguay's preference would be for this defendant to not receive a life sentence, if the district court were to take that into account, for it to actually impact the sentence, the court would have had to actually depart from the guideline range.
that's correct. And I just want to also be very clear, Your Honor. Gonzalez-Valencia never argued below that, even in the supplemental sentencing memorandum, that the district court in its discretion should consider Uruguay's preference or request for him not to have a life sentence. The argument was that as a matter of law, his extradition was conditioned on him not receiving a life sentence, and therefore the district court couldn't impose a life sentence. But he never argued that as a mitigation factor, because Uruguay requested this, the district court should exercise its discretion and depart from the guidelines range. That argument wasn't presented at all. And so I think that's no basis for saying that the district court erred by failing to explicitly address that on the record at the sentencing hearing.
Did the Uruguay court give any reasons for its request?
So he challenged his extradition in Uruguay, and the criminal court, the lower level of court, imposed the condition, and it based it, as detailed in his supplemental sentencing memorandum, it based it not on the treaty, but on sort of Uruguayan domestic law and other things outside of the treaty. And so the lowest court imposed that condition. But then again, I think the key points are that when Uruguay requested those assurances, the United States did not provide them. Uruguay was aware of that and then extradited him anyway.
I understand that, but what I'm asking is, what was the reasoning of the Uruguay criminal court for making that request?
I believe, Your Honor, that it was based on domestic law and some, international, perhaps international agreements. I know that it was not based on the treaty, the extradition treaty between the United States and Uruguay.
Or the particular circumstances of the defendant?
No, Your Honor. If the court has no further questions, we urge you to affirm the conviction and sentence here.
Thank you.
Thank you.
My turn? All right. Normally I do this off the iPad, and this was I just learned that I'm no iPads allowed up here. So I am going to hopefully end with a few quotes that maybe can convince this court that this is in fact plain error. So the two of them are from Bigley, and the last one is from McKeever, both cases from this court. By failing to consider the defendant's non-frivolous mitigation argument, the district court committed plain error. Bigley again. When a judge fails to address a defendant's non-frivolous mitigation claim based on a 3553A sentencing factor, a reviewing court and the public cannot adequately evaluate the judge's sentencing selection.
Was that argument made at the sentencing hearing then?
No, that's why it's plain error.
Unfortunately, if what the government tells us is accurate, we don't have it. The district court didn't have any mitigation arguments in front of them.
I'm not sure I
The
follow.
arguments were, what's a mitigation argument?
The mitigation argument would be that out of respect for the law, which is a 3553A factor, the judge should have considered Uruguay's condition that an expression as a matter of, and I can answer Your Honor's question as to why it was there. It should have considered Uruguay's expression and condition that he not receive a life sentence. That's a mitigating factor. That as a matter of international comedy, the extraditing state said, don't do this. The reason the extraditing...
Sorry, but the government just said that that wasn't the argument made below. The argument made below was that it was a condition of the extradition. So it's more of a legal question, not a mitigating thing that the court can take into consideration under 3553A.
And that's why Your Honor was asking me, well, how I meet the plain error standard. because this precise nature of this argument this wasn't artfully raised by a counsel below. It was raised, as my opposing counsel says, as this was a binding condition. I mean,
So
here's
your
an
argument has morphed because before you were saying the argument was in the papers and then she didn't
right.
expressly state it. And now you're saying, now that you're confronted with the fact that this particular argument about mitigation wasn't in the papers, now you're making a different argument, which is that this is something the court should have just thought of on its own.
No, we say it in our brief. So the first part is that the district court was required under Rule 32 to resolve this dispute. There's a dispute in the papers. The defense papers say you are bound by Uruguay's condition because there was a reasonable understanding by Uruguay that the US would comply. The government says that was not the understanding. That was a legal dispute that the district court didn't resolve, but was required to resolve under Rule 32. We discussed that at length in our brief, especially in the reply brief.
Why wasn't the district court's sentence a resolution of the dispute?
Because the district,
Because the defendant said no life sentence. That's a condition of my extradition. And the district court pronounces life sentence.
because the
Does that
district court,
resolve the dispute?
no, because the district court didn't mention their dispute. This district court didn't rule on it. Look at how the rest of the district court, I mean, this is a district court that when there's an issue before her, she rules very clearly. She lays out the two sides and then rules. An honest view of this record is that it got missed. We can assign blame wherever, but to say that she ruled on it is a judicial fiction. She didn't rule on it. We know she didn't rule on it because she's very clear on everything else. And then this big elephant just got silent. It somehow got missed. You know what? As the Supreme Court was just talking about in Rosales-Morales, there's some times where mistakes just happen. This is a complex process. The problem is a mistake happened in a case where some guy got life.
And the mistake was his client not asking for this ruling on the record.
Which ruling, Your Honor?
The
Sorry to
ruling
ask
that
you a
you're saying She
question.
should have addressed on the record. The counsel never asked for it. So I don't see that as the district court's mistake. I see that as counsel's mistake.
Fine. I mean, counsel asked for one of the rulings in the papers. That's where we were.
Not what we're talking.
You're talking about the mitigating factor argument, right? That wasn't raised. That's
I'm talking
why.
about either one. There was no request that the district court address anything that you're saying here at the sentencing hearing, hearing. And your claim here is that she needed to address it at the sentencing hearing. That's what we're talking about. So the mistake was not the district court's mistake. It was counsel's mistake.
But Your Honor, if I ask for something in my sentencing papers and the district court doesn't rule on it at the sentencing hearing, whose fault is that?
It's your fault for not asking the court to do so.
So I asked for it in my sentencing papers, the district court doesn't do it, and then I have to ask for it
So
again.
I'm a former district court judge. I was
Yes.
a trial judge for 12 years also on another court. And at sentencing, there could be an enormous record before the court. And it's up to the parties to focus the court on what they think are the most important issues. And there's a reason why we have precedent that says a district court's not required to tick off everything that's in the papers because it's not practical. Some sentencing hearings last more than a day.
Right.
The record can be enormous. So it is up to counsel to focus the court on what are the important issues that need to be addressed on the record at the sentencing.
So if it's counsel's fault, let's just assume it's counsel's fault. Who bears the brunt of the fault right now?
What does the law say?
The client at this point, well, I think this is a classic plain error situation. And I think that the court should exercise its discretion to send it back because of the gravity of what.
We have now heard 15 minutes of argument about whether the issue should have been raised. Number one, number two, whether it was raised. Number three, what the district court should have done after being alerted to this issue. What we haven't heard is a single word about the merits. If the district court, if this were placed before the district court, what is the argument that says that the district court should give a lesser sentence because a criminal court in Uruguay requested that?
Oh, that,
What is the merits argument on this?
so there's Supreme Court, that's a great question, Your Honor, thank you. It's a question that goes back to Rauscher in the Supreme Court, which says that our domestic courts, as a matter of international comedy, should provide deference to the requests and conditions of the extraditing courts as a means of protecting United States citizens.
So, I don't think that's the law.
That is the law.
The deference, yes, when we have made a representation during the extradition, but we've made no guarantee during the extradition, and there's no law that I'm aware of that says because a criminal court in Uruguay requested something, the United States has to agree to it. We didn't agree to it.
I agree with you. That doesn't say you have to agree to it, but having to agree to it and considering it are different. Think if it were on the other foot. And this court ordered extradition. I know it doesn't, but just imagine it ordered extradition. And it said very clearly in the United States, it's very important to us that this guy cannot get more than a 30-year sentence. He's a United States citizen and it's important. Can you please consider that? And then Uruguay, or pick a state, went ahead and imposed life sentence without even mentioning this court's statement that was then affirmed by the Supreme Court that it's important to us that he doesn't get it. That matters. That's the kind of comedy. How would this court feel? It's like, well, we said to you, we're going to extradite, but please take a real look at giving him less than 30 years.
All right, I've got your argument.
Thank you, Your Honor.
counsel.
Thank you.
The case is submitted.
Case number 20-5320. Ange Samma et al. Versus United States Department of Defense and Pete Hegseth in his capacity as Secretary of Defense appellants. Mr. Janda for the appellants, Ms. Kim for the appellees.
Mr. Janda.
Great. Thank you, Your Honor, and may it please the court. Sean Janda for the federal government. I'd like to reserve 5 minutes of my time for rebuttal, if I may. Congress has provided that non-citizens who serve in the military may take advantage of an expedited path to naturalization, but only if they have served honorably. And Congress has further provided that the military shall determine whether any particular non-citizen meets that standard. Notwithstanding that statutory language, the district court concluded that the statute provides no authority to the military to establish standards defining the boundaries of the honorable service requirement. That decision is irreconcilable with the statutory text and is undercut by the substantial history, the decades-old history of the military making honorable service determinations and characterizations and exercising substantial discretion in fixing the boundaries of the requirements that service members must meet to receive.
Can you focus on mootness, please?
Sure, Your Honor. So our best understanding is that the case is not moot, primarily because parts of the injunction continue to course the department's conduct, and because the department is actively considering this issue and may choose to reimpose new minimum service requirements.
But if we think it's moot and we vacate the lower court's decision, doesn't that solve all your problems?
Yeah, we don't have a sort of particularly strong objection to that. I think we try to give you our best understanding of the circumstances, and I think candidly we don't want the court or the plaintiffs to feel misled if there's a Munsingware vacatur and the department chooses to reimpose new requirements at some point shortly thereafter. I think we want to make everyone clear that that is certainly a possibility. But so long as the court sort of follows the Munsingware practice and vacates the judgment below, we do not have a strong objection to that resolution of this appeal. But if there are no other questions on mootness, I'm happy to.
Do you agree that the case is otherwise moot?
So we think that the two primary things are the fact that the injunction continues to course the department and the fact that this may well be reimposed at some point in the future. As we explained in our supplemental brief.
But being reimposed at some point in the future doesn't prevent this from being moot. That's speculative.
Again, I think our best understanding is that there's a more than speculative chance given that the department is actively considering this issue. But I don't want to fight the court too hard. I think we would be perfectly happy with a decision that vacates the judgment below. And then the third thing.
But a record that just says we're considering it doesn't indicate that it's likely or not likely or anything. It's just, as far as we know, speculative, because we have no idea how things are going as you're considering whether to do this or not. And so it just seems speculative.
Yeah, like I said, I don't think we have a huge objection if the court sort of views the representations that we've been making as not providing a firm basis for thinking that there's a more than speculative chance that the department will do this, so long as the court vacates the judgment. And then the third thing, which I would just say, is that we focused a little bit in our supplemental brief on some concerns we have about the possibility that plaintiffs in the future will argue that the judgment, if it remains in place, has a preclusive effect on.
But any
but-
argument that relies on the district court judgment, if we vacate it, none of that matters, right?
Correct. As we have no strong objection to the court vacating the judgment below.
It just, to summarize what we've been discussing, it seems to me that to the extent that you're saying we might do this again, that's moot because it's speculative. And to the extent you're saying the remaining judgment or the judgment of the district court, if it remains in effect, hampers us or does things, that is taken care of if we vacate that judgment.
Again, I don't want to say I agree with the first part. I mean, I think, as I said, our best understanding is that it's more than speculative at this point. But I don't want to fight.
It's your best understanding without telling me that you're likely going to do this. That has no effect on my decision making. Like, if your understanding is it's not speculative, but you don't share with the court why that is so, I can't rely on that, can I?
No, sorry, I was not trying to say that sort of my personal understanding is that it's more than speculative. I was trying to say that our best sort of reading of this court's precedents and the more than speculative standard sort of as applied to the representations that we have made to the court is we think that those
All right,
representations.
so
but
is there any prior precedent of this court that says just because you're considering it, that makes it not speculative? Because my reading is it has to be more than that. But
no,
tell me what cases you're relying on that inform your best understanding.
I don't think we have a particular case that says that, Your Honor. That being said, I think
Then what
as
is
we
the
did.
basis of your understanding of our case law?
So I think that the discussion in the public citizen case that we talked about in our supplemental brief, which I think finds that the possibility of the conduct reoccurring being not more than speculative was based on the understanding that there were kind of a number of outside contingencies that would have to happen before the sort of plans for the project would be reinvigorated. Here, as I said, we don't think there's any kind of outside circumstances that would have to change. I mean, the department could decide tomorrow if it wanted to issue new requirements.
All we're relying on is the internal deliberations of the government, which we're not privy to.
Right. As I said, I don't want to fight the court too hard about this. I think if you look at the representations we've been able to make to the court and you think that those are speculative, we do not object to the court finding that the appeal is moot and vacating the judgment. If there are no other questions, I may be happy to address the merits if the court would like, or to cede my time. Whatever.
On the merits, it seemed to me that the parties spent a lot of time debating, what's honorable service, that type of thing. But it seemed to me that implicit in a finding of honorable service is some period of time to evaluate service. And that didn't seem to be the focus of the briefing, but that seemed to be a textual argument that supports the secretary's ability to impose some kind of time limit or time requirement being in service. Because how do you determine if it was honorable if there's no time limit to evaluate that?
Right. I think that's exactly right, Your Honor. I think that certainly is articulated in the Miller Declaration that's in the joint appendix that was sort of the declaration that explained why the military imposed the particular policy in October 2017. And I think that underlies what's been an exceedingly long history of the military considering length of service and in many circumstances refusing to certify honorable service on sort of service members' first day in service. I mean, going back to World War I, we cite the Patterson case about someone who had sort of been in the military for, I think, 4 days, and the military saying that's not enough time to have earned an honorable characterization of your service. And so I think that's exactly right. I think Congress would find it pretty surprising to learn that they had enacted a law that requires the military, the day that someone steps off the bus at basic training, to certify that they have served honorably in the sort of hours that they have been at basic training. And so I think certainly the court, were it to reach the merits, would be well placed to rely on, I think, that history and that sort of common understanding of what Congress has done here. If there are no further questions,
Right,
be happy to speak with them.
May it please the court, Scarlett Kim on behalf of plaintiffs' appellees. This case concerns the expedited pathway to citizenship Congress created for non-citizens serving in the military during armed conflict so that they have an opportunity to naturalize before deploying overseas and risking their lives for our country. As a threshold matter, this case is moot because the government rescinded the challenged policy nearly 4 years ago, because the government is merely considering whether to issue a new policy, and because the class is closed and the injunction has no ongoing effect.
And you agree that if it's moot, we should vacate the district court's decision?
We do not believe that vacatur is warranted, Your Honor, under U.S. Bancorp. In U.S. Bancorp, the Supreme Court stated that the question of whether or not to vacate is dependent on a principal condition, which is whether or not the party seeking relief from the judgment below mooted the action via voluntary action. And we believe here that it's quite clear that the government mooted the action against it through its own voluntary action. It sought 5 extensions on its merits briefing, and then it voluntarily rescinded the policy and has taken nearly 4 years to merely study the issue. It has had a long runway to reinstate or reissue a new policy, and it has not done so.
But why should we leave that precedent outstanding when there hasn't been an opportunity for appellate review because of the mootness that occurred during the pendency of the case?
I think the Supreme Court in Bancorp is clear that when the government itself, or as it were, the defendant, has through its own voluntary actions, not through happenstance,
But it
mooted
doesn't
the
seem
action.
like they were trying to manipulate jurisdiction or mootness or anything of that nature here. And it just seems incorrect to leave something on the books where the litigation was not complete.
So in Bancorp, the Supreme Court didn't suggest that the voluntary action had anything to do with manipulating the court's jurisdiction. There, the mooting action was a settlement, and there was no question that the settlement was entered into in bad faith. And I think—
So we have some discretion here. Why should we exercise our discretion to leave this district court?
Well, I think—
intact?
Yes, Your Honor. I think there are potentially some troubling consequences if related to the gamification of litigation. Let's say an agency disagrees with the district court judgment below. It could always seek to try and moot the action to simply vacate instead of
But that just
pursuing
doesn't
the
seem to be the
appeal.
case here. Like they wanted this appeal to proceed so that they could litigate on the merits. They think they're correct on the merits. So I just don't, but go ahead. Why should we?
Yes, Your Honor. I would just simply state that I think as a matter of principle, Bancorp is clear that when the party has mooted the action through its own voluntary action, vacatur is not warranted. And I would just point the court to two circuit—
Bancorp, the Justice Scalia's opinion also said that there may be extraordinary circumstances that would warrant vacating the judgment, even when it was the defendant who lost that brought about the mootness. What kind of circumstances do you suppose he had in mind?
I'm not quite sure what those circumstances would entail, Your Honor. I can't think of what would be so extraordinary as to warrant vacatur in
That was a settlement.
Yes, Your Honor.
And the problem that the court faced was because the losing party didn't file a motion to vacate it. Right?
I believe, Your Honor, that—
It was a court of appeals decision, not a district court.
my understanding, Your Honor, is that the motion to vacate, the parties in the decision not to file the motion to vacate was in the underlying facts for Munsingware, but not for Bancorp, Your Honor. I think in Bancorp that motion may have existed,
Oh,
but
yeah, you're right.
but that the primary condition that the Supreme Court pointed to was voluntary action. And the only other thing I would say on this, Your Honors, is that there are 2 circuit opinions which hold that where an agency rescinds a challenged policy at issue, vacatur is not warranted. And I would just point the court to those opinions because there are opinions in the circuit that are totally on all fours with rejecting vacatur in these circumstances.
And your position on is that if the if we don't vacate, that you would agree to the terms that the district court's judgment does not have preclusive or coercive effect?
Yes, Your
What
Honor.
does that mean? What coercive effect do you have in mind?
So I would rely on the government's representations because the government is the party that has indicated that the judgment may have a coercive effect. And I believe that the government's argument there is that the injunction could be read by future plaintiffs to apply to a future time and service requirement. I don't think that the injunction can be read that way. The government has also said in its briefing that they don't believe it should be properly read that way, only that future plaintiffs might read the judgment that way. The injunction, I think, is quite clearly tied to the specific time and service requirements in the challenged policy.
So the coercive effect would be on any formulation that changed the rule with respect to time of service before one can be declared honorable?
Well, Your Honor, I don't think the injunction could have that ongoing effect on a future time and service requirement, simply because the injunction states that the government is enjoined from withholding an honorable service certification from a class member based on the time and service requirements in the specific policy. So we don't believe that the injunction has a coercive effect on any
What about a
future requirement.
preclusive effect? What is that?
So the government's representations about preclusive effect had to do with the possibility of a collateral estoppel effect, and that's based on the government's reading of the class certification order. The government argues that the class may be considered open because the class definition applies to individuals subject to Section 1 of the challenged policy, and not all aspects of Section 1 were challenged by the plaintiffs below. But I would note, Your Honor, that that the government's interpretation of the class certification order is really based on a truncated reading because the class is actually comprised of two subclasses. And when you read the definition of the two subclasses, those involve individuals who are subject to the time and service requirements in the specific order. So our position is that since the time and service requirements no longer exist, there are no longer any individuals entering the two subclasses.
What
therefore
about
class.
a precedential effect? And the whole point of Bancorp was that the district judges or the district court's order would have precedential effect, and the defendant who lost and then mooted the case cannot have any complaint about that because they're the ones that took the action that prevented appellate review. So if this judgment is not vacated, under your view, even if you put preclusive and coercive, it still could have precedential effect, is that right?
I don't believe so, Your Honor, simply because district court orders are not binding on any other judge and don't serve as binding precedent. And the judgment and order in this case is just so narrowly tied to the specific time and service requirements. And so therefore, we don't believe that there would be any precedential effect on any future district court decision on a future time and service requirement.
We have the authority to say that a judgment of a district court that we haven't vacated shall have no precedential effect. Where do we get that authority? I know of no order coming out of a court of appeals that ever did that.
I'm not sure that that principle needs to be stated, Your Honor, simply because district court decisions don't have binding precedential effect. And so I too cannot think of a particular case that stands for that principle.
Seems to me all of these issues are just matters for future litigation, like whether it has any kind of preclusive or coercive effect. It would just be litigated before whatever court that came before. Somebody would say, this is preclusive or coercive, and the other side would say, no, it's not. I don't know why that's an issue for us to even consider.
I mean, we completely agree, Your Honor, and I actually don't think that any future plaintiffs would argue that the class certification order exerts a preclusive effect or that the injunction exerts a coercive effect moving forward. I think that the slate would be wiped clean if the government were to issue new time and service requirements and there were to be a future challenge to those requirements.
So the best argument for not vacating the district court order would be what?
The best argument, I would rely again simply on Bancorp, Your Honor, and the principle that that the principal condition the court should look to is whether the party seeking relief from the judgment below mooted the action through their own voluntary action. And I think it's clear that the government did so here. And I'll just point to the two cases in the circuit which have held similarly. The first is IA v. Garland, which is a 2002 case, and Center for Science in the Public Interest versus Reagan, which is a 1984 circuit case.
Thank you.
If your honors have no further questions on mootness, I will briefly address the merits. Judge Pan, you asked about the textual argument. And I think here, the parties agree that the key textual term is served honorably. And the parties also agree that it's a term of art that's not defined in the statute.
But nobody can forfeit the plain reading of a statute, and it's now our job to determine the best reading of the statute. And if the court thinks that what we are interpreting here is the secretary shall determine.
Yes, Your Honor. But the secretary shall determine whether someone served honorably. And we think here that the appropriate approach is based on the instruction in George v. McDonough, which is a 2022 Supreme Court case, which the defendants themselves cited in their brief. In George v. McDonough, the Supreme Court instructed that where Congress employs a term of art with a long regulatory practice in the specific context presented by the statute, when Congress adopts that term of art, it codifies the interpretation developed under that specific practice. When the Immigration and Nationality Act was passed in 1952 with the determined served honorably language, Your Honor, it ported over that language directly from the Nationality Act of 1940. And under the Nationality Act of 1940, Your Honor, tens of thousands of non-citizens were determined to have served honorably at the beginning of their service with no time in service requirements during World War II. And we therefore believe that when Congress adopted that language again in 1952, it codified that interpretation. And in addition—
Does that mean it has to be that way, or is it that the secretary had discretion to determine this and determine that that was enough time at that time, but that doesn't mean they can't change?
I have two responses to that, Your Honor. The first is that George v. McDonough is clear that Congress codifies that interpretation, the historical meaning. And in fact, in that opinion, the Supreme Court stated that it's not the question of what the text—
So what do you think has been codified? That it can be done in a day, it can be done in 30 seconds, it can be done in— what has been codified?
Yes, what has been codified is that the Department of Defense determines when the service member presents their request for honorable service certification. And this is only during a period of armed conflict. The Department of Defense must make that determination. And I would just note that the Department of Defense has made this—
I'm sorry, so the applicant can, anytime the applicant wants to apply, sets the time limit?
The applicant does not set the time limit. I would just note that the Department of Defense has had a consistent practice for a century of doing this.
No, I understand. I'm trying to get at
Your
what
Honor.
they're allowed to do, not what they have done.
Yes, Your Honor. Yes, our interpretation under George v. McDonough is that the historical understanding fixes what the authority of the Department of Defense has. And the historical understanding is that when a service member submits their honorable service certification for, in order to determine whether or not they're eligible for naturalization, the statute does not authorize the department to fix a minimum period of time before they can receive the determination.
Get off the bus at basic training and present these papers and—
Yes, and indeed they have. Hundreds of thousands of non-citizens have been able to receive their honorable service certifications this way. And the military has had a consistent practice for making that determination. In the unrelated case of Kiowa, the district court found—
I guess what I struggle with is, how do they make a determination that the service was honorable if there has been no time to do that?
Yes. So in Kiowa, the district court explained what the unrebutted facts showed about what that practice consisted of, Your Honor. And that practice consisted of looking at a service member's record at the moment that the request was made and determining if they were serving active duty or selected reserve, if they had valid dates of service that fell within Section 1440, and if there was any immediate past derogatory information.
So you think there's a presumption that the service was honorable?
I don't think there's a presumption, Your Honor. It's looking at the record at the time that the request is
But
made.
you're saying it's honorable as long as there's nothing that says it wasn't?
Yes, Your Honor.
So that
Yes.
seems to me to be a presumption that it was,
I-
unless it's proved otherwise.
I'm not sure I would describe it as a presumption, Your Honor. I would describe it as simply looking at the record at that time, the service member's record, and determining if there is any information warranting denial of the honorable service certification. I would just make two other points that are contextual, because of course text must be read in context. The first is that Section 1440 is one of two naturalization provisions. Section 1439 is a companion provision, and it provides that in peacetime, non-citizens are eligible to apply for naturalization after having served a year. And we believe that Congress clearly indicated a minimum period of service in one provision and not in another, and that lends itself to the conclusion that Congress omitted deliberately a prescription of a minimum period of service. And the last point I would just make is that this is a naturalization statute, and Congress gets to set the rules for who is eligible for naturalization and when. And it certainly could not have intended the department to substantively amend this priority lane for citizenship that it created for non-citizens serving during armed conflict, but that is exactly what the department is seeking to do. Under the challenged policy itself, it would have completely effaced the Section 1440 pathways to citizenship for selected reservists, one portion of the class, by making them wait 1 year, which is the same time under peacetime as in armed conflict, before they could seek citizenship. And on appeal, their position is even more extreme, which is that they would like to align the service characterization at discharge policy with the honorable service certification at naturalization policy, which would require all service members to wait a minimum of 1 year. Again, that would completely obliterate the Section 1440 pathway to
Well, 1 year
citizenship.
would, but would 180 days?
180 days would not, it would obliterate, or it would efface Congress's intent. I think the legislative history is clear that what Congress
But
intended.
not as clearly as 1 year. 1 year clearly, I think, would
Yes, Your Honor.
conflict. with
Yes, Your Honor.
But
I mean,
180 days, at some point, isn't it sort of an arbitrary and capriciousness question?
I mean, I think our position, Your Honor, is that Congress made it clear that service members should not be subject to a minimum period of time, and that the reason for that was that they wanted service members to be able to deploy as citizens. And in the administrative record, the military states itself that any service member is subject to potential assignment to a war zone after graduating from basic training, which is only 10 weeks. That is far shorter than the 180 days minimum that was set out in the challenged policy.
But could they set a limit that allows them to be naturalized by the end of basic training?
I don't believe they could set a limit, Your Honor, based on what the statute authorizes, which is no minimum period of service imposed.
I want to take you back to the mootness question, because there's a couple threads that seem to me to be hanging, and I want to make sure I understand. On the voluntary secession doctrine, or exception to mootness, you say it doesn't apply if the actor is not mooting the case for the purpose of avoiding litigation. And you say that the defendants here did not institute this guidance, new guidance, for the purpose of avoiding litigation. How do you know that?
I think there are two pieces of evidence that suggest that the government did not act to avoid litigation. The first is that the government does not oppose mootness, and in Public Citizen, the court pointed to that as a factor. And then the other piece of evidence is that in the intervening period, the department has actually taken proactive steps to move away from the rescinded policy, which is just not.
The main piece of evidence is that the government is arguing the case isn't moot.
Yes, Your Honor.
Right, okay. So
Yes, Your Honor.
But there's another aspect of the voluntary succession doctrine, and that says that if it did apply, it applies because the defendant, the losing defendant, could institute the policy again, right?
Yes, Your Honor.
Does that seem inconsistent with the Supreme Court's standing doctrine? The standing doctrine requires that the harm be imminent, but on the mootness doctrine, there's no time limit on when I mean, for all we know, the government 5 years from now will be instituting, but that's not imminent harm. I mean, aren't they inconsistent?
Yes, Your Honor, that's an interesting
rhetorical
doctrinal question. I believe, Your Honor, in Laidlaw, the Supreme Court discussed how the description of mootness as standing set at a later time frame is actually not entirely on point.
Justice Ginsburg.
Yes, Your Honor. And I think what the court pointed to there was when considering mootness, there are other considerations at play, which is why some of these exceptions come in and why there's this question about, is there a likelihood that the behavior could resume? And that's because there are all these litigation resources that have been expended to that date. So that it might make sense for a higher court at that point to potentially see if it might hold on to the case if it is likely that the challenged conduct may resume.
Thanks.
Thank you, Your Honors.
Thank you, Your Honors. I just have a couple quick points I'd like to make, two on mootness and then one quickly on the merits. First on mootness, I think if the court does believe this case is moot, then Munsingware vacatur is absolutely warranted here. I mean, Munsingware itself describes vacatur as the established practice in circumstances where a case becomes moot before appellate review can be had. And we cite at page 16 of our supplemental brief 3 recent Supreme Court cases where the court vacated lower court judgments in circumstances where the government had rescinded the policy in question, sort of mooting the case. And I think those really sort of undermine.
What case you mentioned?
So there's 3 that we cite at page 16 of our supplemental brief. One is Biden against Feds for Medical Freedom. One is, I think, Mayorkas against Innovation Law Lab, and one is Yellen against U.S. House of Representatives. In all 3 cases, all in the last 4 years or so, the sort of government lost below, rescinded the challenge policy for reasons unrelated to the litigation, and the Supreme Court mooted, I think, at least in some of those cases, over objections like those I've heard from my friends on the other side today, that sort of voluntary action shouldn't underbank court support a vacatur. And I think the reason for that, as we explain in our supplemental brief, is that just as an equitable matter, it's not appropriate to force the government to choose between sort of keeping a policy that it would like to rescind for policy reasons unrelated to the litigation and having to forego appellate review of a judgment that may sort of hamper the government's ability to exercise its policy discretion moving forward.
What were the policy judgments unrelated to this litigation that led to the new guidance?
So the memo rescinding the guidance is in the record, Your Honor. It's not a particularly long memo, but I think the department made the determination that it did not wish to enforce the time and service requirements at this point. I mean, I think that's a determination that could change, but I don't think there's any suggestion that that was sort of an attempt to moot the litigation. Obviously, we're here saying that we don't think the litigation's moot. And then the other quick piece I'll say on mootness is, I think
I've read the memo and I don't find any reasoning.
the memo is quite short.
Right.
The department was rescinding the requirements.
And it cites this litigation.
It does sort of mention that this litigation is ongoing. Again, I think, well, 2 things. One is, if you think that this is sort of an attempt to game the litigation, then I think that would sort of trigger the voluntary cessation doctrine, and under which there will be a much higher standard to find mootness in the first place. And so I think it sort of would be inappropriate to say, you know, the government's rescission is sufficiently unrelated to the litigation not to trigger voluntary cessation to keep the case alive, but sufficiently related to the litigation to say that we don't get the benefit of Munsingware. I think sort of one way or the other, either the court should decide the case or it should vacate the judgment below. And like I said, I don't think we have a particularly strong preference between those 2 options, but we do think that either one is required. And the other thing I'll say is, I think the class certification definition and the terms of the injunction are a little bit unclear. I think we have a sort of reasonable concern that the injunction continues to have coercive effect on the department. As recently as October, the plaintiffs tried to.
Why isn't that a matter just for future litigation?
I think to these, I mean, one is, I think if the injunction does have that sort of ongoing effect, then I'm not sure how the court could say the case is moot. I mean, we cite Sarko in our brief.
But it just seems to me that you're saying possibly people will argue that the injunction is in effect, even though it seems to apply just to the particular policy that was in effect at that time, which has been rescinded. But you're saying somebody could argue in the future that this continues to have presidential or coercive effect. It just seems to me that you would just litigate that before whatever court you're in front of.
So I think there's 2 pieces of the injunction, Your Honor. So one piece we think applies only to the minimum service requirements. That's the piece that says you can't enforce them. There's another piece that says that the government has to sort of certify or return Form M426s as expeditiously as possible, and in any case within 30 days, it's sort of limited to the class members. And so that
part you don't have a problem with. You're doing that anyway.
we are trying our best to do that. I think we certainly have a problem with sort of being subject to an ongoing injunction that we have to comply with on pain of contempt. And I don't.
That's not just for the class members, though, that are the subject of the litigation.
The injunction is just for the class members. That piece of the injunction is just for the class members. So the sort of policy more generally is to try and return within 30 days if we can.
Yeah, I'm just saying, is that policy apply beyond the class members?
I think the policy applies generally. The class sort of comprises, I think, everyone or just about everyone who would be subject to or who would be able to take advantage of Section 1440 at this point. So I'm not sure that there's been daylight.
There's a dispute about that. If any of their side said there's no new members of this class.
Yes, I mean, I'm sort of happy to hear that. I wasn't aware that the plaintiffs had that interpretation of the class. But again, I think that our fundamental point is that there is some degree of ambiguity in the sort of ongoing effect of the judgment and the scope of the class. If the court sort of looks at, I think to say that this case is moot, the court would have to think that there is no ongoing sort of coercive effect on the government. And so, if the court thinks that, and I think our request would be that the court, A, should vacate for the reason we discussed, but B,
that it may not, in fact, have an ongoing coercive effect, but the government thinks it does, so it's doing stuff. Like, I just don't know how we take that into account.
I think if the court thinks that the injunction has no ongoing effect, that would be a sort of necessary conclusion to dismiss this appeal as moot. And if the court says that's how we understand the injunction, again, I think we would be perfectly happy to hear that. What we don't want is to end up in a situation where we've sort of lost the ability to get appellate review of a judgment and injunction that we think is just absolutely erroneous on the merits. And sort of in the future, then find out that we were wrong about the ongoing effect of the judgment or about the definition of the class. And so I think that all of those problems are solved by just vacating the judgment under Munsingware. I think that would be the most appropriate thing. But I certainly don't think that the court could properly say, we're not going to decide whether the judgment has ongoing effect, but we're going to hold that the case is moot at this point. I think sort of the no ongoing effect is kind of a logical antecedent to the appeal being moot. If the court has no further questions, I'm happy to skip the point on the merits that I was going to make.
Thank you.
Thank you. Case is submitted.
This honorable court can adjourn until Friday, January 31st at 1:30 p.m.